Good evening, ladies and gentlemen. So can anybody tell me, right, where we stopped last time? I mean, last session? Dinesh, can, just please refer to your note and tell me where we have stopped. Nobody? Nobody is responding. Can you hear me, first of all?
Yes, sir.
Right. So please refer to your note. And what is the topic that we discussed last time?
The payment of gratuity.
The payment of gratuity, right? So the Grativity Act, right? So 1 minute. So is this the one we discussed? Is this a payment of gratuity? How far, right?
Finally, we did the example question, sir.
Okay, right. Example in the sense, how do we calculate the gratuity?
Yes, sir.
Okay. Did we complete it or not?
Completed.
Completed, right. So then before that, right, before the, so you need to understand there are two main component or three main component is required to obtain the gratuity, payment of gratuity or gratuity benefits. Number one is completed 5 years of service. That is must. That is the main component. And second, the workplace that where you are working, the employer has to employ at least 15 or more workers. Okay? At least 15 or more workers. And the other one is your employment has to be ceased. I mean, you have to retire or resign. Okay? So please, before the calculation, what you have, the noted down before calculation.
We wrote the equations, sir, how to calculate the payment of gratuity.
Okay, right. How to calculate the payment of gratuity, right? Rate of payment, this is the one, right? Am I correct? Do you see the presentation?
No, sir.
Oh, 1 minute, 1 minute. Sorry. We need to share it. Sharing. Okay. Now, do you see the presentation now? Rate of payment, section 6 of the Grativity Act.
Yes,
Monthly
sir.
rated workman, half a month last drawn salary, right? Divided. Okay, right? Sorry, not divided, right? Half a month last month's salary or wage into period of service. Any workman, I have noticed that, the lot of students, repeatedly I have explained to them in previous examinations, the first one they calculate properly. But the second one, I don't understand. What they do is, the lot of students, I don't know how, I have not, explained in such a way that they have calculated. This is my formula. I have always, given this formula. Any other workman means daily wage workers. Okay, any other workman, right, means here, let me put daily wage workers. Let me put like this. Daily, sorry. Daily wage, so not DIL, right? Daily, DAIL, daily wage workers. So for daily wage workers, this is the formula. 14 days wage or salary. Wage put like this. Let me change it. O daily wage, sorry, monthly wage, salary or wage, monthly salary or wage. 14 days wage or salary into period of service. The most of the students I have noticed that, the very recently I have conducted, prepared 3 question papers so far in English medium. So what they have done was, most of 90% of them, I don't know how, right, such thing have been, explained to them. What they have done is 14 days into 26 days, right? They have multiplied, right? Not 14 days, the daily wage, right? They have multiplied daily wage by 26 days and divided by 2 and multiplied by period of service. But that is, I don't know, right? That is wrong. What you have to do is, you have to take the daily wage and multiply it by 14, right? And then you will get 14 days salary. Instead of half a month, means 15 days, you will get 14 days salary and multiplied by period of service. Okay. In the case of piece-rated workman, calculating the daily wage or salary is like this. First, you have to calculate the daily wage. Wage or salary. Sorry, some spelling mistakes here. Wage or salary received by the employee for the last 3 months should be divided by the number of days they worked. Right? Then, right? And then what do you, well, then make, so then you will get average daily wage. So what you will get? Average what? Daily wage. Do you hear me? So this is equal to, let me put equal, right? Not, sorry. Equal to average daily wage. So Grativity, then. Grativity. Just 1 second. Sorry, I have
You are
muted,
muted.
sorry. So this is in the case of piece-rated workman, calculating daily wage or salary. How is it? Wage or salary received by the employee for the last 3 months should be divided by the number of days of work. Then you will get average daily wage. Then how do you calculate gratuity for the, in the case of piece-rated workers? Average daily wage into multiplied by 14 days multiplied by number of years of service. Is it clear? පැහැදිලිද නෝනාවරුනි මහත්තුරුනි මෙනවියනි?
Yes, sir, it's clear.
Right.
Sir.
මොනවා හරි ප්‍රශ්නයක් තියෙනවා නම් ඕන භාෂාවක් දෙබලෙන් නැතුව අහන්න. සිංහල හෝ ඉංග්‍රීසි දෙකෙන්. ප්‍රශ්නයක් නැහැ. දැන් මේක මං කිව්වේ මේ ඩේලි වේජ් එක හැමදාම මම දැන් පේපර්ස් 3ක් හදලා තියෙනවා. පේපර්ස් 3ක් පහට කණ්ඩායම් 3කක පේපර්ස් බලලා තියෙනවා. මමයි පේපර්ස් හදන්නේ. මං උගන්වපු අයට. හැමදාම මේ ගාන වරද්දනවා. පළවෙනි එක හරියට හදනවා. දෙවෙනි එක මොකද්ද අටමගලයක් කරනවා 14 වැඩි කරනවා 28න්. 26න්. sorry 14 නෙමෙයි. ඩේලි වේජ් එක දෛනික වැටුප ඒගොල්ලෝ 26න් වැඩි කරනවා. 26න් වැඩි කරලා ඒක දෙකෙන් බෙදනවා. ඒකල number of years of service වලින් වැඩි කරලා ගන්න. මම දන්නේ කවුරු එහෙම උගන්වනවද කියලා මම උගන්වලා නැහැ. කොහේ හරි තැනකින් පොතකින් බලාගෙන වෙන්න ඇති. පොතේ නෙමෙයි තියෙන දේ. මම always I encourage you, don't look at textbooks. Right? textbook නෙමෙයි මේවට බලන්න ඕන. මේවට බලන්න ඕන මොනවද? වැඩි දුර යමක් ඕන නම් මම මේ කියන දෙයට වඩා බලන්න මොනවද බලන්න ඕනේ? If you need extra knowledge, what are the documents that you need to refer? ඉතින් කතා කරන්නේ නැහැ නේ කවුරු.
So any references can you
There are no, I'm telling you, right? This is law. There are no references. There are number of books written by various types of people, but those are textbooks. Textbooks are not required for this subject because this is law. You have to refer to the act and the ordinance. Understand? Right? So you can't go behind, you know, what someone else has said. There are books, but we never know whether book explain the real situation and then the actual fact. Law is law. You have to refer to the act, enactment, legislation. Is it clear?
Yes, sir.
Right. If it is HRM, look at textbooks. Yes, of course. HRD, yes, of course, textbooks. But for law, law is law. You have to refer to the legislation. If you go to the Labor Department, everything is there. You can download it. And if you can't understand this English, read simultaneously Sinhala and English, both together. But I have given you, I'm giving you the entire important things, right, stipulated in the legislations. Okay, so people think that, you know, you need textbook, but forget about textbook. This is law. You for law you have to refer to the legislation and the case law. Now, case law means judgments, but forget about for the movement judgments, right? At least if you need further understanding, refer to the legislation passed by the parliament. I have captured main component, very important, right? Everything important from the legislation, and I'm teaching you. These are not from textbooks. These are from the legislation. Okay? Right. And you learn the surcharge as well, no? This part? I hope so. Now, what do we mean by completed service? Here you have seen that completed here, where is it? At the beginning, sorry. A workman who has completed 5 years of service. For the entitlement of gratuity, a workman must complete 5 years of service. What do we mean by complete service? Completed service. What do we mean by? What about 4 years and 11 months? Is it 5 years, or can it be considered as 5 years? Is it possible to consider it as 5 years? What do you think? Please interact with me. Kavindi, what do you think?
So I guess without including the holidays and
No, forget
everything.
about the holidays for the moment. I will come to that point later. Right, in my next explanation. So if he has 4 years and 11 months and he is resigning, is he entitled for gratuity?
No.
No. Completed means exactly 5 years. But when we calculate 5 years, he's the entitled leave and everything, all are inclusive. Those are not matters, right? Because those are he's entitled for leave and everything. These are very, very, I mean, there are no issue. But during that period, assumes that there was a major strike. So people, including this man, went on 15 days or 1 month strike continuously. So that 1 month, right? Can that 1 month be excluded when the completed 5 year is calculated? Is it possible? Ara strike හිටපු මාසයක් strike කියලා හිතන්නකො. ඒ මාසෙ අඩු කරන්න පුළුවන්ද අවුරුදු 5 කාල සීමාවෙන්?
No, sir.
බෑ. ඒකයි මේ කියන්නේ. Services which is interrupted by approved leave on any ground whatsoever, a strike, a lockout, cessation of work not due to any fault of the workman, whether such interrupted service was, right, rendered before or after the coming into operation of this act. Whether such uninterrupted or interrupted service was rendered before or after the coming into operation of this act. මොකද්ද මේ කියන්නේ? මෙන්න මේ වගේ අවස්ථාවන් මේ පනත ආවට පස්සේ සේවයට බැඳුනා හරි ඊට කලින් අයටත් මොකද කරන්නේ? මේවා අඩු කරන්න බෑ කියන එකයි කියන්නේ. පැහැදිලිද? Is it clear?
Yes, sir.
Everybody? What about other people? So very few people. I don't know, Sai. Sometimes we have to add this one. Yes. Anything else? Hasini, do you understand? What තේරෙනවද දරුවෝ? නෑ මට ඇහෙන්නේ නෑ වාගේ මොකවත්. Completed service means uninterrupted service and includes menometic. So you take your own note. I'm not reading. Right? First subtopic is completed service. Subtopic is you have to take your own note. Completed service. Subtopic. And after that, take your note. Completed service means uninterrupted. Right? Bada no, kada no, service එක. And ඒකට ඇතුළත් වෙනවා. මොනවද? Approved leave අරගෙන හිටපු කාලෙත් අවුරුදු 5 ගණන් ගන්නකොට uninterrupted service එක. Strike තිබ්බත් uninterrupted service එක. Lockout තිබ්බත් එහෙමයි. Cessation of work not due to any fault of the workman. Right? So take your note. ඔයාලම ලියා ගන්න මේක. හරිද? Once you finish, let me know. Finish? Have you done?
Okay, sir.
Yes, sir.
Right. Now, completed service, this is very important, is the period of interdiction calculated to the completed, is the period of interdiction, right? Calculated to the completed service. Meaning that interdiction, the period of interdiction can be calculated to the completed service. That is the question. Is the period of interdiction calculated to the completed service? Ceylon Petroleum Corporation versus the Commissioner of Labor Court of Appeal writ application. It says, when the employee was interdicted, there was no cessation of employment. සේවා ගිවිසුම කඩ වෙලා නැහැ. තාවකාලිකව ඉන්ටඩික් කරලා හිටියයි කියලා සේවක සේවය සම්බන්ධතාවය බිඳිලා නැහැ. ඒකයි කියන්නේ there is no cessation of employment. Cessation, ඒ කියන්නේ කඩවීමක් වෙලා නැහැ. It was a cessation that continued not due to any fault of the workman. ඒක සේවකයාගේ වරදක් නිසා නෙවෙයි. It is common practice that when an employee is not physically present and not working in an institution during a period, he could be treated as on no pay leave, and those who are on no pay leave are also not entitled for their salary and allowances. But that does not mean that they are not in service during that period. I hope you understand. මේ නඩු තීන්දුවේ පැහැදිලිව කියනවා ඉන්ටර්ඩික්ෂන් කා සේවය වැඩතහනම් කරපු හිටපු කාලය තුල ඒක නෝපෙප් එකක්. ඒකෙන් අදහස් වෙන්නේ නැහැ එයාගේ රැකියාව හිමි වුණා කියලා. සේවක සේවය සම්බන්ධතාවය නැති වුණා කියලා අදහස් වෙන්නේ නැහැ. ඒ නිසා එයා නැවත සේවය පිට ඉන්ටර්ඩික් කරලා తాවකාලික වැඩක් නේ. ආපහු නැවත සේවයට ගත්තාම ඒ ඉන්ටර්ඩික් කරපු පීරියඩ් එකත් අර අවුරුදු 5 කැල්කියුලේට් කරනකොට සැලකිලිට ගන්න ඕන කියලා එකයි කියන්නේ. Right? Do you understand?
Yes, sir.
Right. Right. Topic. මේකම ලියාගන්න. Complete. Is the period, subtopic, is the period of, question එක හැටියටම ලියාගමු. Is the period of interdiction. Interdiction. Is the period of interdiction. Is the period of interdiction calculated to the completed service? Is the පොඩකින්න just is the කියනවට වෙනුවට මෙහෙම දාන්න. Can not is, can the period of interdiction be calculated? Be calculated. Can, not is. Can or could. Can, sorry. Can, just 1 second. Can the period of interdiction be calculated? Right. Yes. Can the period of interdiction be calculated to the completed service? Right. එයාට ලියන්න. The answer is yes. The answer is yes. Yes. The period of interdiction, the period of interdiction must be taken into consideration must be taken into consideration. O included when the completed service within bracket 5 years, within bracket 5 years, close the bracket, is calculated. You don't need to write this, the entire court decision, right? So continue. No, next para. The court decision, the court decision, sorry, court of appeal decision, sorry, the court of appeal decision, the court of appeal decision the court of appeal decision within bracket CA capital, court of appeal CA slash writ 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 824 stroke 2008. Close the bracket. Close the bracket. With regard to with regard to Ceylon Petroleum Corporation versus the Commission of Labor, is one of the classic examples, one of the classic examples in this regard. Just give me 1 second. Just 1 second. Okay, next topic. Favorable gratuity. Favorable gratuity. Favorable gratuity. Favorable gratuity. So, what do you mean by favorable gratuity? According to law, if you are entitled for gratuity, you will be paid half a month's salary, last known salary, for each year of service. What do we mean by favorable gratuity? Is there anyone from the private sector here? What do you mean by favorable gratuity? Favorable means favorable. According to law, half a month's salary per each year of service. But favorable gratuity means more than that. More than that. Okay? So, how it is not by law, but law permits for such favorable gratuity through collective agreements, sometimes award of an industrial court or arbitration, or any other agreement. Right? Any other agreement. Right. ඒ කියන්නේ නීතියට අනුව නම් මාස භාගයක වැටුප තමයි අවුරුද්දක සේවා කාලයකට ගෙවන්න ඕනේ. Enhanced gratuity කියලත් මේකට කියනවා. Right? නැත්නම් favorable gratuity. එතකොට ඒ කියන්නේ ඒවා එන්නේ නීතියෙන් නෙමෙයි. සාමූහික කිවිසුම් මගින්. සමහරට උසාවි ඉන්ඩස්ට්‍රියල් කෝට් එකකින් හරි ආබිට්‍රේටර් කෙනෙක් හරි ඩිසිෂන් එකක් දෙන්න පුළුවන් ඒ වගේ වෙලාවක. සහ කිවිසුමක්. කිවිසුමක් තියෙනවා හාම්පුතයි සේවකයයි අතර. ඒ තුලින් favorable gratuity එන්න පුළුවන්. Okay. Subtopic favorable gratuity. Subtopic favorable gratuity. Right. Under that, first para, favorable gratuity. That is the subtopic. Where the gratuity favorable to a workman. Favorable to a workman. Favorable to a workman. Is governed by first bullet is governed by comma first bullet a collective agreement සාමූහික කිවිසුමක් a collective agreement or second bullet award of an industrial court or arbitrator or ORO. Third bullet. Any other agreement, comma, Neelang rule in next para. The gratuity should be computed. In accordance with in accordance with the terms of that. In accordance with the terms of that. සාමූහික කිවිසුමක එහෙම නැත්නම් වෙනත් ඇග්‍රීමන්ට් එකක ඉන්ඩස්ට්‍රියල් කෝට් එකකින් ආබිට්‍රේටර් කෙනෙක් දීපු ඩිසිෂන් එකක් අනුව ඕනේ ග්‍රැටිවිටි ගණනය කරන්න. ඒව තමයි අපි කියන්නේ enhanced gratuity නැත්නම් favorable gratuity කියලා. සාමාන්‍යයෙන් මාස භාගයකට වඩා වැඩියෙන් දෙනවා. සාමාන්‍යයෙන් මාසෙක දෙන තැන් තියෙනවා. මාස 3 කාලක දෙන තැන් තියෙනවා. මාස භාගය තමයි නීතිය. ඊට වඩා වැඩියෙන් දෙන ඒවා තමයි favorable කියන්නේ. ඒව එන්නේ එක්ක collective agreement එකකින් නැත්නම් industrial court එකකින් arbitration decision එකකින් එහෙම නැත්නම් වෙනත් agreement එකකින්. Right. Next para. That gratuity or terminal benefits. This is called sometimes one of the terminal benefits. That gratuity or terminal benefits. That gratuity or terminal benefits set out therein ඒවායේ set out therein must be set out therein must be more favorable to the workman than than the gratuity payable under the act. Ladies and gentlemen, I will stop at 10 o'clock, right? So sometimes we go without break, huh? And we have to think about twice because the very few students. I'm going to propose to the management that this is group number 11 and 12, whether there is a possibility to amalgamate with 13, right? 13 also, the catching up catching up you. I think according to my note, today is our which session? I mean, how many sessions so far we have conducted? Today is 16th session, right? 16th. Am I correct?
Yes, sir.
Right. So number 13 also, we have gone around 7. So not 7, 8. 8. So if we speed up the, if we have more lectures, fix more lectures for group 13, then we can, the 11, 12 and 13, we can conduct together. Because, having small students, a small number of participants, I'm also boring. And it's because, we have to think about the other factors as well. So let me think about it and propose to the management. Then we may have a, the little, the higher group. If your lectures, somehow, right, stop forever, not a stop, right? A few lectures for this group and more lectures for English medium group number 13. And then we can meet, somewhere within 1 month, right? Together we can conduct all together. Otherwise, okay, right. What I said, that gratuity or terminal benefits set out therein must be more favorable to the workman than the gratuity payable under the act. Payable under the act. Act, when you say act, A capital, always. If you put simple act, ක්‍රියාකාරකම. පනතකට හැමතිස්සෙම පනතක ඇක්ට් එක කියනකොට ඒ අකුර කැපිටල් වෙන්න ඕනේ. Right. Right. Is there anyone from the private sector here? Nobody? Kavindya, are you working?
No, sir.
Right. Anybody? No. Okay. You know, this Grativity also complicated. I'm repeatedly telling you, don't ask me textbooks. I do not recommend any textbooks. I recommend the Labor Department has long back ago prepared අත්පොත එක සිංහලෙන් තියෙන්නේ. කම්කරු නීති අත්පොත කියලා එකක්. එක සිංහලෙන් තියෙන ඉංග්‍රීසියෙන් නැහැ. I do not recommend any other textbooks because textbooks, I know that, you know, some professor or doctor from the university, right, Colombo University, I think the professor has written a book, right, on this industrial law. But I do not recommend because those textbooks does not contain the court decisions. New court decisions are coming every day. Those are not incorporated. And sometimes they are not practitioners. If you are not a practitioner, right, you don't know, right? Sometimes, you know, you can't abstract the real idea from the law. The real idea can be abstracted from the law by a real practitioner. So therefore, I do not recommend anything, but if you need further knowledge, you look at the law, act, or enactments, or legislation. Grativity Act, Termination Act, Industrial Dispute. I did read it. Okay, right. Next one. Right. We have court decisions in this regard. Favorable Grativity. Ceylon Bank PLC versus the Commissioner General of Labor. Court of Appeal writ application decided on 21st 2015. Gunaratna Justice, 3-bench judges, and Pereira, Justice Pereira, Deepali Vijayasundara, Justice Deepali Vijayasundara. These are the Court of Appeal judges. These were. What it says, when gratuity payable to an employee is higher than the statutory minimum, it is governed by any other agreement as in the case in hand. If it is so, gratuity should be computed in accordance with such agreement and the employer would be stopped from denying, again, denying, right? Just 1 second. Yeah, there is no mistake, right? Such benefits to an employee. So we have court decision. So next para, ඊළඟ para එකෙන් ලියන්න decided case. Decided ඊළඟ para එකෙන් ලියන්න decided case කියලා ඉරක් ගහන්න. Decided case, put a dash. Decided case, decided case, put a dash. Ceylon Bank PLC versus, VS means versus. Ceylon Bank PLC versus the Commissioner of Labor, comma, CA, capital A capital, CA, writ. CA means, what do you mean by CA?
Court of Appeal.
Court of Appeal, yes. CA, writ. Writ ආච්චාව කියන එක. Writ. WRIT, writ. 891 stroke 891 stroke 2009. This is the case. Right. Let me explain to you another very interesting case. Singers Industries, Singer Sri Lanka, Singer Ceylon, Singer Industries Limited versus Ceylon Mercantile Industrial and General Workers Union, CMU. This is Supreme Court decision. Huh? This is a Supreme Court decision. Let me explain this one first. The Singer Sri Lanka Limited offered a 1/3 of, not 1/3, sorry, 3/4 of gratuity offered in writing, writing to the union operating in the Singer Sri Lanka, Singer Ceylon, now Singer Sri Lanka, Singer Industries. The company wrote to the operating union, that is Ceylon Mercantile Industrial and General Workers Union, CMU in short. They wrote, they communicated in writing to the union that the company is willing to pay. The law is 50%, no? Half. Law is half a month. But instead, company offered 3/4, 75%. It means 3/4 means 75% of a monthly salary as gratuity for each year of service to its employees with more than 20 years of service. This was offered. But however, the union did not accept it, neither accept nor refuse. Instead, they were demanding 1 month gratuity. Company offered, legally they are entitled for 50%, I mean half a month's salary. But company offered enhanced gratuity. It means 75%, I mean 3/4. In writing to the union. For those, the company was willing to pay 3/4 or 75% of the monthly salary as gratuity for those who have worked more than 20 years of service when they retire. The union neither accept nor reject. Instead, they were arguing 1 month salary for each year of service. But finally, argument went. Finally, what do you call this? The couple of people retired. The company paid half a month's salary, I mean the legal one, half a month. Then these people did not accept this and lodge a complaint with the Labor Department saying that the company has given in writing to the union saying that the company is willing to pay 3/4 or 75% of the last known salary, right? For those who have completed 20 years of service. But when we retire, the company just pay the legal one, I mean the half a month salary. So that is a violation of, I mean, the company breach of, the contract. That was the argument. And then the Labor Department refer this matter for an arbitrator. Arbitrator gave a decision that, yes, the company has communicated to the company, the union, indicating that they are ready to pay 75% of the last known salary, but they have not paid. So therefore, the company must pay. That was the decision of the arbitrator. And against the decision of the arbitrator, company went to the Court of Appeal by way of writ application. Right? The Court of Appeal also affirmed the decision of the arbitrator. Right? Affirm the decision of the arbitrator. So, and then again, company went to Court of Appeal, sorry, Supreme Court. Supreme Court. Okay? So, what has happened? I'm not reading everything. Let me tell you the final one, the decision. Sorry. So, okay, right. I'm quoting the decision, part of the decision. The appellant had instituted Court of Appeal, writ application, number එක දාලා, Court of Appeal, seeking inter alia to quash the purported arbitral award of the fourth respondent, sometimes referred as post dated so and so, which ordered the petitioner to pay, it's not an arbitrator, Labor Department, Commissioner General, ordered to pay 3/4 of the month's salary as gratuity for each year of service to its employees with more than 20 years. Accordingly, I would allow the appeal and set aside the judgment of the Court of Appeal, right, dated, and direct that a mandate in the nature of the writ of certiorari be issued, causing the impugned arbitral award dated so and so, and the Gazette notification produced by. So, මොකද්ද මේ කියන්නේ? මම සිංහලෙන් කියන්න. මෙහෙම ගියා 175ක් දෙන්න පොරොන්දු වෙලා දුන්නේ නැහැ. Labor Department එකට arbitration නෙමෙයි, Labor Department එක දුන්න තීරණයක් නැහැ ගෙවන්න ඕනේ කියලා. ඒකට විරුද්ධව ගියා Court of Appeal එකට. Court of Appeal එකෙමුත් කිව්වා කොමසාරිස් ජෙනරාල් කියපුක හරි කියලා. කම්පැනිය ගියා ඊට පස්සේ කොහෙටද? Supreme Court. Supreme Court එකෙන් කිව්වා කොමසාරිගේ තීරණයත් වැරදි, Court of Appeal එකේ තීරණයත් වැරදි. එයා එහෙම ගෙවන්න ඕනේ නැහැ. එයා භාගය ගෙවලා තියෙන නීතියට අනුව ඒක හරි කියලා. So what is the basis of that? What is the point? Can anybody think about it? Why Supreme Court decided that the company does not need to pay 3/4. They have paid the legal one, 50%. Even though they have, communicated in writing the company is willing to pay 75%, they did not pay, that is okay, correct. They have paid the legal one. Why? What is the point? Right? To decline the decision of the Court of Appeal and the Commissioner General by the Supreme Court. What is the point? Can anybody think about it? මොකද ඇයි එහෙම කරේ සුප්‍රීම කෝට් එක? කොමසාරිස් දීපු තීරණය ඒක නිවැරදි කියලා කෝට් ඔෆ් අපීල් එක කිව්වා. කෝට් ඔෆ් අපීල් එකට ඊට පස්සේ ගියා යා සුප්‍රීම කෝට් එකට. සුප්‍රීම කෝට් එක කිව්වා උඹලා දෙන්නම හරි කෝට් ඔෆ් අපීල් එකත් වැරදි. ඒ නිසා ඒක අයින් කරා. ඇයි? මොකද පොයින්ට් එක? Can anybody think about it? මම එක වචනයක් කිව්වා ඔයාලට. දැන් enhance grativity එන්න ඕනේ මොනවා වුණා නන්ද? මොනවා නන්ද? enhance grativity මේ මතකද? Where the grativity payable to a workman is governed by a collective agreement, award of an industrial court or arbitrator, any other agreement. මෙන්න මෙතනින් තමයි මේක එන්නේ. Any other agreement කියන එක. හරිද? එතකොට ඇයි එහෙනම් මේක ශ්‍රේෂ්ඨාධිකරණය එහෙම ගෙවන්න ඕනේ නැහැ කියලා තීරණයක් දුන්නේ? What is the point? Can anybody think about it? කවුරුත් කතා කරන්නේ නැහැ. Kavindya, do you have any idea?
Maybe from the prior agreement between the employer and the employee, they have agreed to pay another kind of gratuity.
Yes, agreed. You are trying to say something. You know, if something is there like, any other agreement between employer and the workman or trade union, right? The company, the point is this. There was no agreement. There was no agreement. Why? Company made a proposal. In order to have an agreement, there should be an offer and acceptance. Offer was there, but no acceptance from the trade union. They neither accepted nor rejected. So they were arguing. So in order to have an agreement under the what do you call the law of agreement, or what do you call this agency law, not agency law, contract law, right? Or law of contract, right? Law of contract. In order to have any other kind of agreement, two conditions must be fulfilled. One is offer. The other one is acceptance. Company offered, but the other party did not accept. So therefore, there is no agreement. That is the point. Do you understand? Terunada? Is it clear?
Yes, sir.
මේ කම්පැනි එක 100ට ලාස්ට් ඩෝන් සල් නීතියෙන් ගෙවන්න ඕන 150යිනේ කියන්නේ අන්තිම වැටුපෙන් 150යි භාගයයි කියන්නේ 150. කම්පැනිය පොරොන්දු වුණ කම්පැනිය ඔෆර් එකක් දුන්නා. අනේ අපි 175ක් ගෙවන්නම් මේ සේවා කාලේ 120ක් තියන අයට කියලා. කවුද? හාම්පුතුන් sorry ට්‍රේඩ් යූනියන් එක මොකද කරේ? ඒක පිළිගත්තේ නැහැ. ඒක ප්‍රතික්ෂේප කරෙත් නැහැ. ඒ වෙනුවට ඒගොල්ලෝ 1 month ඕනේ කියලා ආගියු කර හිටියා. ඔය අතරේ සේවක කණ්ඩායමක් මොකද උනේ රිටයර් වුණා. කම්පැනි උන්ට ගෙව්වේ පනතේ තියෙන විදිහට භාගයයි. ඊට පස්සේ ගියා ලේබර් ඩිපාර්ට්මන්ට් එක කිව්වා නෑ උඹලා පොරොන්දු වෙලා උඹලා ලිඛිතව දීලා තියෙනවා කමියුනිකේට් කරලා තියෙනවා 175ක් ගෙවන කියලා ගෙවන්න ඕනේ කියලා. වැරදි ලේබර් ඩිපාර්ට්මන්ට් එක. ඊට පස්සේ කම්පැනි ඒකට විරුද්ධව ගියා කෝට් ඔෆ් අපීල් එක. කෝට් ඔෆ් අපීල් එකත් කළේ මොකද නෑ කමියුනිකේට් කරලා තියෙනවා 4න් 3ක් ගෙවන 75ක් ගෙවනවා කියලා නිසා ගෙවන්න ඕනේ කියලා කමිෂනර් ජෙනරල්ගේ තීරණය නිවැරදි කියලා දුන්නා. කම්පැනි ගියා ඊට පස්සේ සුප්‍රීම කෝට් එකට. සුප්‍රීම කෝට් එකෙන් කිව්වා උඹලා දෙගොල්ලම වැරදි. කෝට් ඔෆ් අපීල් එකත් වැරදි. කොමසාරිස් ජෙනරල්ගේ තීරණයත් වැරදි. කෝට් ඔෆ් අපීලුත් වැරදි. ඇයි මෙතන කොමියුනිකේට් කළාට ඇග්‍රීමන්ට් එකක් මේ any other ඇග්‍රීමන්ට් එකක් ඇති වෙලා නැහැ. ඇග්‍රීමන්ට් එකක් ඇති වෙන්න නම් මොකද වෙන්න ඕනේ? offer එකක් තියෙන්න ඕනේ, acceptance එකක් තියෙන්න ඕනේ. There was an offer but no acceptance. So therefore there is no agreement. Is it clear? Right.
Yes, sir.
Another court case also we have, but I'm not going to, discuss all these, the things. Right. Now, we just another subtopic, power of the commissioner and subtopic, power of the commissioner and other officers to enter and inspect premises, work premises. This is, ladies and gentlemen, very clear, right? These are the, the power that the commissioner has. He can enter and inspect all documents, right? No one can violate it. No one can interrupt. By law, commissioner has been empowered. Commissioner means Commissioner General of Labor is the main actor. He has all powers. So he can delegate his powers to additional Commissioner Generals, commissioners, deputy commissioners, assistant commissioners, and labor officers. But those who are working in the labor department as accountant, right, clerical staff, even though they are holding the labor department identity card, they cannot enter into any work premises. They cannot, right? But the power has been vested with the labor officers, assistant commissioners, deputy commissioners, commissioners, and additional commissioners generals by the commissioner general, who has the power, and he has delegated only for these categories. They can enter, they can get the all required document and enter any workplace and obtain a required document. No, none other than that. Okay, right. So you will take your own note, right? I will make it larger because I don't need to read. Yes. Power of the, is it visible?
Yes, sir.
Right. You take your own note. I will give you a couple of minutes. You done? Is it finished? Did you
Yes,
finish?
sir.
Okay. What it says, the commissioner or any other officer authorized in that behalf by him in writing for the purpose of carrying out provisions of this act may enter and inspect all reasonable hours by day or night any premises or place for examining any books or document. Make copies, examine any person who he has reasonable cause to be believe is an employer or a person who has made default in the payment of any sum of this act. It means, ගයන්න පුළුවන් ආයතනයකට ගීල පරීක්ෂා කරන්න පුළුවන් වැරද්දක් කළා තියෙනවද කියලා හොයන්න පුළුවන්. No person shall obstruct or resist the commission or any officer authorized by the commission in writing in the exercise of any power under subsection. Forget about subsection, right? So no interruption. Okay. And then offenses and directors' liability. Any person who contravenes or fails to comply with any provision of this act shall be guilty of an offense and shall, on conviction by a magistrate, be liable to a fine not exceeding 500 rupees or to imprisonment of either description for a period not exceeding 6 months, or to both such fine and imprisonment. මේ පනත මගින් හිමිවන, ඒ කියන්නේ වසර 5ක සේවා කාලයක් තියෙන සේවක 15කට වඩා සේවය යොදවපු කාම්පුතෙක් එයා රිටයර් වෙනකොට නැත්තම් රිසයින් වෙනකොට එහෙම නැත්තම් එයාගේ සේවය අවසන් කරනකොට පාරිතෝෂික පනතේ අවසන් වරට ලැබූ වැටුප වගේ මාස භාගයක වැටුපක් වැඩ කරපු සර්විස් එකට කාලයට ගෙවන්න ඕනේ. right? එහෙම නොකළොත් මහේස්ත්‍රාත්වරයෙකු ඉදිරියේ නඩු පවරනවා කම්කරු දෙපාර්තමේන්තුව. එහෙම නඩු පැවරුවාම ඒ අදාළ මුදල ගෙවනවට අමතරව රුපියල් 500 rupees වලට අමතරව, right? මාස 6ක සිර දඬුවමකට හොය දෙකටම යටත් වෙන්න සිද්ධ වෙනවා. When offense under this act is committed by a body of persons, මේ body of persons කියන්නේ මේක. දැන් ඔබට මම උගන්වලා තියෙනවා employer කියන්නේ කවුද කියලා. employer කියන එක definition එකේ ඔබට මතක නම් a person who employs a workman or on whose behalf someone who employs a workman. ඔය දෙකම එකයි. ඔය on whose behalf කියන්නේ හවුල් ව්‍යාපාරයක් සීමා සහිත පෞද්ගලික සභාගමක් නම් හවුල්කරුවෝ සහ අධ්‍යක්ෂක මණ්ඩලය තමයි අයිතිකාරයෝ වෙන්නේ. තනි පුද්ගලයෙක් නම් තනි පුද්ගල ව්‍යාපාරයක නම් තනි පුද්ගලයා. දැන් අධ්‍යක්ෂක ලොකු ව්‍යාපාරයක නම් හවුල් ව්‍යාපාරයක නම් හවුල්කරුවෝ නෙමෙයි පුද්ගලයෝ බඳව ගන්න. හවුල්කරුවන්ගේ තීරණ මත කවුද HR මැනේජර් හරි HR ඩිරෙක්ටර් හරි කවුල් සීමා සහිත සමාගමක නම් අධ්‍යක්ෂක මණ්ඩලය වෙනුවෙන් HR ඩිරෙක්ටර් හරි HR මැනේජර්. එතකොට අධ්‍යක්ෂක මණ්ඩලය වගේ කියන්නේ. ඒක තමයි on whose behalf කියන්නේ. And තුන්වෙනි එක on behalf of someone else, a person who employs, අන්න ඔතන තමයි third party contracting. ඒජන්තවරයෙක් එන්නේ. එතකොට ඒ සියලු දෙනා මේ කියන්නේ body of where an offense under this act is committed by a body of persons. ඒ කියන්නේ හවුල් ව්‍යාපාරයක් නම් හරි සීමා සහිත පෞද්ගලික සමාගමක් නම් හරි. එහෙම නැත්නම් trade union එකක් නම් ඒක. If the body of person is a body corporate, every person who at the time of the commission of that offense was a director or an officer of that body, or if the body of person is other than the body corporate, every person who at the time of the commission of the offense was a member of that body shall be deemed to be guilty of such an offense. ඒ කියන්නේ හවුල් ව්‍යාපාරයක නම් සරල භාෂාවෙන් කිව්වොත් හවුල් කරු. සීමා සහිත සමාගමක නම් අධ්‍යක්ෂක මණ්ඩලය. ට්‍රේඩ් යූනියනයක නම් ඔෆිස් බෙයාරස්ලා. අන්න ඒගොල්ලෝ වග කියන්න ඕනේ. Is it clear?
Yes, sir.
Right. Offences and directors liability subtopic. Offences and directors liability. First para. First para. Okay, before you write it, let me raise a question. It is, okay, let me raise a question. Okay, right. There is a company X called company X. You work for that company. You work for that company. But later, my company, company Y, I acquire the company X. I acquire or merge my company and the company X. Merge or I acquire the company X. So, if you have completed 5 years of service, who is the liability? Which company has the liability to pay compensation? So not compensation, gratuity. Company or me? My company is company Y. Who has the liability? If you have completed 5 years with the company X, who has the liability to pay? If you have completed 5 years of service, this is so complicated, huh? So complicated. So you can't get any knowledge from textbooks. We were the practitioners, so we know A to Z this one. We have faced many problems. So what do you think? Only Kavindya is answering. What do you think? Who has the liability? If I acquire company X, you has worked for the company Y. Sorry, company X. So at the time of acquisition, if your employment is not continued, then who has the liability to pay the compensation? It's a company X. But those who have not completed 5 years, then the responsibility goes to me, company Y. But let me tell you, you have worked for the company X 5 years. Then you join with me as well, maybe as new employer. Sorry, without, not new employer, as the, the same employer, you will join with my company. Even though the gratuity is paid to you for the service you rendered for the company X, by the company X. I have the responsibility to pay you the gratuity for the entire period. I have the responsibility to pay the, this is so complicated, right? I will explain to you one by one. So now, offenses and directors liability. This is not easy to understand. මම එක සිංහලම ඉංග්‍රීසියම දෙකෙන්ම කියන්නම් තේරුම් ගන්න පුළුවන් විදිහට ඊට පස්සේ. හරි. මේකයි. දැන් මම සිංහලෙන් කියන්නම් මෙහෙම. කම්පැනි කියලා X කියලා කම්පැනි එකක් තියෙනවා. මගේ කම්පැනි එක Y. මම කම්පැනි X කියන එක මම අයිති කර ගන්නවා. එතකොට ඔයගොල්ලෝ ඔක්කොම සේවකයෝ මගේ ළඟට ආවොත් ඔයාලගේ කොහොමත් අවුරුදු 5ක් සේවා කාලයක් නැති මිනිසුන්ගේ මගේ කම්පැනි එකට එනවා නම් ඒ පරණ සේවා කාලයටත් එක්ක ග්‍රැටිවිටි ගෙවන්න පාරිතෝෂික ගෙවීමේ වගකීම මට එනවා. අවුරුදු 5ක් ආපු අයට එන්නේ නැහැ. හැබැයි එන්නේ නෑම කියලා කියන්නත් බෑ. ඇත්තටම මම අවුරුදු 5ක තියෙන සේවකයොත් ඒ විදිහටම මගේ කම්පැනි එකට ගත්තොත් කවදා හරි දවසක ඔයගොල්ලෝ කම්පැනි X එකට වැඩ කරපු කාලෙටත් එක්ක මට සිද්ධ වෙනවා ග්‍රැටිවිටි ගෙවන්න ඕගොල්ලෝ. එතකොට ඒක කරන්න පුළුවන් එහෙම නොවෙන්න නම් කොහොමත් අවුරුදු 5ක් නැති සේවකයෝ මගේ කම්පැනි එකට ආවොත් අවුරුදු 4මාරක් තියෙන සේවකයෙක් එනවා. එතකොට එයාගේ අවුරුදු 4මාරටම මගේ ළඟ වැඩ කර තව මාස 6ක් වැඩ කරොත් මම මුළු 5ටම ගෙවන්න ඕනේ. ඒක very clear. හැබැයි අවුරුදු 5ක් හෝ ඊට වඩා වැඩියෙන් තියපු සේවකයන්ට මම මගේ කම්පැනි එකට ඕගොල්ලෝ ගන්නවා නම් මම දැනගන්න ඕනේ අර කම්පැනි X කියන කම්පැනි එකෙන් ඔයාලට ඒ වෙනකොට ගෙවන්න ඕන ග්‍රැටිවිටි මුදල් ප්‍රමාණය අඩු කරලා ඒක මම තියාගෙන මොකද කවදා හරි දවසක මට ඕගොල්ලෝන්ට ගෙවන්න මම තියාගෙන ඒ කම්පැනි එකට අදාළ මුදල ඒ කියන්නේ ඇක්වයර් කරගන්න උඩ අපි මුදලක් ගෙවනවානේ ඒක ගෙවන්න ඕනේ. මොකද කවදා හරි දවසක ඕගොල්ලෝ ඔක්කොම ගත්තොත් මට ඒ වගකීම එනවා. හැබැයි එහෙම නැතුව වගකීම එන්නේ නැති ක්‍රමයක් තියෙනවා. අවුරුදු 5ක් වැඩ කරපු සේවකයෝ සහ ඊට වඩා වැඩි අයට ග්‍රැටිවිටි ගෙවන්න පුළුවන් පළවෙනි X කියන කම්පැනි එකේ. ඒකල ඒගොල්ලන්ගේ සේවය අවසන් කරන්න පුළුවන්. අන්න ඔතන ප්‍රශ්නයක් කියලා. සේවය අවසන් කරනකොට සේවය අවසන් කිරීමේ පනත යටතේ වන්දි ගෙවන්නත් ඕනේ. X කියන කම්පැනි එකට. එහෙම කරලා ඕගොල්ලෝ මට පුළුවන් අලුත් සේවකයෝ හැටියට බඳව ගන්න. එතකොට මට වගකීමක් එන්නේ නැහැ. එහෙම නොකර ඍජුවම මම ඔයගොල්ලෝ ඔක්කොම ටික මගේ කම්පැනි එකට ගත්තොත් මම තමයි කොටු වෙන්නේ සියලු දේවල් වලට. So I will be the responsible for everything. Is it clear?
Yes, sir.
Right. So offenses and directors liability. Right. First para. Any person who contravenes or fails to comply with any provision of this act, A capital act, A capital, shall be guilty of an offense offense and shall, comma, shall, comma, on conviction by a magistrate, on conviction by a magistrate, on conviction by a magistrate, comma, comma, be liable to a fine, දඩයකට, to a fine, F-I-N-E, fine, not exceeding not exceeding ₹500 or ₹500 or to imprisonment, බන්ධනාගාරගත වීමකට, to imprisonment, imprisonment of either, EITHER, either description for a period of not of, for a period not exceeding 6 months, 6 months, ORO, to both such fine and imprisonment. Next para. Where an offense under this act, A capital, where an offense under this act කියනකොට A අකුර capital වෙන්නේ යා. Where an offense under this act ඒ කියන්නේ මේ ඔය ඒ ඕනෑම තැනක act ACT කියලා දානකොට ඒ අකුර capital දැම්මොත් එතනින් අදහස් වෙන්නේ නීතියක් කියන එක. ඒ අකුර simple දැම්මොත් එහෙම එකෙන් අදහස් වෙන්නේ ක්‍රියාකාරකමක් කියන එක. හරි? So where an offense under this act is committed by a body of persons, by a body of persons, by a body of persons, then කියලා ඊළඟ රූලෙන් simple A, then simple A, simple A, if the body of persons persons is a body corporate, comma, every person every person who at the time of the commission, of that offense, ඒ වැරද්ද කරන අවස්ථාවේ commission of that offense, එම වැරද්ද කරන අවස්ථාවේ offense was a director කෙනෙකු වෙලා හිටියා නම් was a director or officer of that body, ඒකේ නිලධාරියෙක් වෙලා හිටියා නම් ORO. Simple B, next ඊළඟ ruling. Simple B. If the body of persons is other than a body corporate, comma, is other than a body corporate, comma, every person who at the time of the commission of the offense, වැරද්ද කරන අවස්ථාවේදී at the time of the commission of the offense, වැරද්ද කරන අවස්ථාවේ was a member, සමාජිකයෙක් වෙලා හිටියා නම් was a member of that body, ඒ body එකේ සමාජිකයෙක් වෙලා හිටියා නම්, comma, shall be deemed to be guilty of such offense, right? ඒ වැරද්ද කරන අවස්ථාවේ හිටපු කෙනා ඒ වැරද්ද කරන අවස්ථාවේ හිටියේ නැති කෙනෙක් මේකට අයිති වෙන්නේ නැහැ. හරි? right. Next subtopic we are going to deal with, right, Subtopic, restrictions on payment of gratuity. Restrictions on payment of gratuity. Restrictions on payment of gratuity. Within bracket, subtopic, restrictions on payment of gratuity, within bracket. Forfeiture of gratuity, FOR, FEITURE, forfeiture of gratuity. Close the bracket. So, ladies and gentlemen, if you made some, unnecessary thing as a worker, like fraud, misappropriation of funds, willful damage to the property of the employer, causing the loss of good, article or property of the employer, then the money, the gratuity equivalent to the amount of damage can be held or forfeit from your gratuity. ඔබ යම්කිසි වැරද්දක් කළා තිබුණොත් මූල්‍ය වංචාවක්, right, damage එකක් ආයතනයේට, හාම්පුතාට, එවැනි වෙලාවක ඔබට හිමි gratuity එකෙන් ඒ damage එකට සමාන මුදලක් රඳවා තබා අඩු කරන්න හාම්පුතාට අයිතිය තියෙනවා. පැහැදිලිද?
Yes, sir.
Right. මේක යටතේ ලියන්න ඊළඟ ඒකේ යටතේ any workman to whom a gratuity is payable under this act, A capital, මමත් පෙතර වරද්දලා simple දාලා තින්නේ A capital, and of this act, and whose services have been terminated for the reason of කියලා පල්ලෙන් එකින් එක bullet form හරි තරු හරි දාලා ලියා ගන්න. Reasons of. First bullet, fraud, FRAUD, fraud. First bullet. Second bullet, misappropriation, අවභාවිතය, misappropriation of funds of the employer. හාම්පුතාගේ funds, අරමුදල් අවභාවිතා කිරීම. Misappropriation of funds of the employer. Third bullet, willful damage to property. of the employer. හිතාමතාම හාම්පුතාගේ දීපොළවලට කරන හිතාමතාම කරන හානියක්. Willful damage to property of the employer. OOR. Fourth bullet. Fourth bullet. Causing the loss of goods. නිෂ්පාදන භාණ්ඩ විනාශ කිරීම. හරි loss. Comma. Causing the loss of goods, comma, articles O. Property of the employer. Right. ඊළඟ ruling ලියන්න. Next ruler. ඊළඟ ruling ඡේදය නෙමෙයි ruler. Shall forfeit. 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 Shall forfeit. රඳව ගන්න පුළුවන්. Forfeit. Such grativity. එවැනි පාරිතෝෂිකයක්. To the extent a permanent, to the extent of the damage. විනාශයේ permanent, තරමට. OOR. Loss. 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 Caused by the employee. Right. Next para. There is a court decision. There is a decided case. On this regard. In this regard, sorry. There is a court decision in this regard or decided case in this regard as well. That is a Bauer and Company. A Bauer. BAUR. Bauer Company kahala ඇති ඔයගොල්ලෝ. Right. A Bauer and Company Limited versus VS versus කියන්නේ අපි දාන්නේ VS නැත්නම් V එක විතරයි ඩොට් එකක් එක්ක. The Commissioner General of Labour. CGL කියලා කෙටියෙන් ලිව්වත් හරි. CA, C capital A capital, stroke, Court of Appeal, stroke, writ, 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 stroke, number NO 1033 stroke 1033 stroke 2005. There are many cases. I'm not going to discuss all these things. One is enough. Now, my next one is so complicated. Next one. Present employer to count services of workmen under past employee in certain circumstances. ඒ කියන්නේ වර්තමාන සේවා යෝජකයාට සිද්ධ වෙනවා පරණ සේවා යෝජකයා ළඟ වැඩ කරපු සේවකයන්ගේ ඒ සේවා කාලයත් සැලකිල්ලට ගන්න සමහර අවස්ථාවලදී. Where an employer sells or otherwise, right, alienates, again, ඒකාබද්ධ වෙනවා. Any land or establishment within a period of 5 years of his becoming such employer, the period of service of workman, any workman, under that employer shall be added to the period of service of that workman under the new employer in computing the gratuity payable to workman by a new employer. මේ කියන්නේ ළමයි මං X කියන කම්පැනි එක Y කියන එක විසින් අත්පත් කරගත්තා නම් X කියන කම්පැනි එකේ අවුරුදු 5කට වඩා අඩු සේවා කාලයක් තියෙන සේවකයෝ ගෙට වගකීම gratuity ගෙවීමේ වගකීම කියන්නේ ඒ සේවකයෝ අලුත් කම්පැනි එකට ගන්නවා නම් වගකීම යන්නේ අලුත් කම්පැනි එකට. පැහැදිලිද? කොහොම නමුත් I'm going to stop now. There are only 5 students. Only 5. Except me, including me, 6. I don't know whether there is a LPEC people as well. No. Right? Only 6. Sorry, 5. Except me. So therefore, I'm going to wind up exactly 10 o'clock. So Kavindya, you have to remind me that we have to start from slide number 32. Do you hear me?
Yes, sir.
Right.
Slide number 32, right?
Yes. We have to
Okay, sir.
start from slide number 32. Right. So today I'm going to wind up, my session because, this is, from this point onwards, we're so complicated because you can't get this knowledge from any textbooks. Even from reading, by reading or referring the act, because these are practical things. Practical. We have gone to court, right? We have argued, right? We have experience. So we are sharing our experiences, practical experiences. So remind me. So I will, for the moment, so let me stop this one and good night for everyone.
Good night, sir.
Okay, good night.
Good night, sir. Thank you.
Night.